Ebusiafo na adofo ya mu nyina akwa biem Alpha OneTV ne da semu tv sese makoso ansa ne so bekoso ade all the latest updates na brem se na bia mo so meden be keep update na mo ho die ko bi enso ready emfie ni nchim ne enka de won nchim enra ne beto dwa Supreme Court ruling na mo de beto dwa no raising a teacher no enra na just am de brain na raising no ebia wonya nti ya bekwa akwoti ni nyina fine no ati ase ye mu ncheche mu na yede aba na we in a raise a lot of tensions, it raise a lot of controversies. Be brave amount for na Ghana is it a baby a druno? If any ya be dress abri, how come say interpretation we in a young crowd for our Supreme Court a cuckoo dam monim de go school to say na English a actual to one say no more tears. Amount for a raise a lot of concerns. The back with tin in our kamani iden. Yatias na adi by no affect NPP for constitution. Adi by no affect NPP for constitution. And as you speak, NPP for no, she say omo yira mo. Case omo ankasa dia ko Supreme Court no. Omo ana she say no omo nu omo ho. Because no money interpretation say na beba. In NPP constitution mo de govern omo party no. Article be a defa enema constitution we no canon Ghana constitution ne can emu anum ye de omoye free inti Afenyo Markin the case ne kwaya say this interpretation abano affect omo so wo ho as abria so speak no omo da kofa nse mebra bro mama say no so bon kro mo de bo Afenyo Markin say de no akofa bay ho because as you speaking on party constitution if be can say the women are there na abamba binjina so the kilo be seat vacant no e happy on party ni mo omo ehia say obi be declare ehia say obi be tro bibi automatically then chaos be na see en couldn't go see sanje chemu nyina to that no na eti reason no ankasa nti Supreme Court no ejina so this ruling the eba
the minds of the Supreme Court justices to make some sense of their judgment on the true and proper interpretation of Article 97(1) GNH as coming up next here on Ghana Tonight, and also in relation to the vacant parliamentary seats controversy. In fact, this is one that a number of you have been waiting for, the said reasoned ruling of the justice of the Supreme Court on this particular case. They brought finality to the true and proper meaning of Article 97 GNH, that's 1 GNH, and also the full details of it we have about 109 pages, which we're going to tease out the major and the standout, as it were, areas within this 109-page ruling of the judges of the Supreme Court, explaining the circumstances under which a member of parliament is deemed to have vacated their seats according to the 5-2 majority decision of the House. An MP can only be considered to have vacated their seat if they change their political identity and remain in parliament under the new identity. You want to understand this? Follow us closely. Because that is the point you make is very important, underscoring this the reasoning behind this particular part of the ruling, because what we have seen is that, for instance, the parties have an influence in who even becomes a leader of the various caucuses in parliament, right? And then now you are saying that based on this ruling, the Supreme Court is essentially saying that the political party on which an MP is elected cannot dictate.
They should not be dictated
as to whether or not the person is fit to represent the constituents, depending on the person's decision to either go independent or otherwise. But let's look at the NPP constitution, right? And then
and even before, after that, I'll show you something interesting.
Perfect. Now let's look at this. This is what the NPP constitution says, and let's put it on the screen right now. It says expulsion of a member. A member may be expelled from the party, and it goes on and on. And let's flip to the next one. It says, in the third point, it says forfeiture of membership. A member of the party who stands as an independent candidate against the officially elected member of the party, or who joins or declares his or her support for another political party or for an independent candidate when the party has sponsored a candidate in a general election or by-election automatically forfeits his or her membership of the party. So this one clearly captures the punishment for an intention. But the Supreme Court says that the intention cannot be punished in the current parliament. Because if you look at it, look at the notice of poll of all those who have decided to go independent, right? And we have it. This is the notice of poll in the Suhum constituency. The incumbent member of parliament, Cha0ṣ, on the ticket of the NPP, who decided to go independent, is there. This is how the polling, that's the ballot paper is going to appear. You have Kesi Protozwa of the NPP, the sponsored candidate of the party is there. Prince Ado, the NDC candidate, Emmanuel Wiafe, and Cha0ṣ, the incumbent NPP MP, is going independent. Let's look at the next one. The next one as well is the case of Cynthia Morrison in the Central Region. This Aguna West, Christopher Atta, the sponsored NPP candidate is there, and Asinofori Dangbe of the NDC, and then Cynthia Mamle Morrison is there as well as the incumbent MP on the ticket of the NPP and going independent. Let's look at Amenfi Central. Amenfi Central, you have Peter Kwachaka there as well. So the Supreme Court says
no. So this is in respect of the next parliament. This has nothing to do with the current parliament. And when you look at what they say are the elements that they formulated, that one, the MP must leave the party under which he was or she was elected. So let's do the analysis. Has any of those MPs left their parties as we speak? Do we know?
Well, the NPP constitution says they will automatically leave if they decide to contest as independent candidates.
That will be a matter for the the NPP to deal with. In any case, I'll show you, we'll go back into history, and the Supreme Court has helped us to see that there have been instances where members of parliament declare their intention or file nominations to contest as independent candidates, and they were still in parliament. Not one MP, not two MPs, not three, as many as 5 of them.
Perfect.
The Supreme Court took judicial notice of that. Let me show you that real quickly. So here we go. And as far as 1996, there was an independent member of parliament for Kintampo, Gladys Insau. She was re-elected in 1996 on the NDC ticket. She entered parliament as an independent candidate. She did not lose her seat. In 2004, you had Dr. William Akoto, NPP MP for New Ebrim from 2001 to 2004. He retained his seat while running as an independent candidate in the 2004 elections. It doesn't end there. It continues. This is a very popular one. Joe Wise.
Yes.
First entered parliament as an independent candidate for Bekwai. 2009 to 2012. He later contested the election in 2012 to be re-elected on the ticket of the NPP. He didn't lose his seat. The only person who unfortunately lost his seat was the former MP. Now there's a final one. He was also an independent candidate. He contested the primaries while he was an NPP primaries while he was an independent candidate in parliament.
Abusia for the younger city where some chichimun na batches NPP for no sisini jabi go muche matches yeveka omonu omo Ṛegṛet pa because I didn't know more party constitution munye free the mother constitution Ghana constitution no sabrino aba interpretation aba affect you mo sisi no as you speak in sana ebadia so be declare and also because support obi krampo NPP no kasa or support mahama said the baby a trim nom didi hopes no I say no muntimi fast am running deal be abim because hopes in the no omu declare keke some support alan our from party na we dear koye obi eno wo film or tino independent constitution is there be any years the for I just say sad for no ye be kwaku timu chichimu yi amihu dinti Supreme Court no nipa 5 age now so edit can say bamba bin actions no taking their own constitution in conclude.
So I mean they dealt extensively with the matter of jurisdiction because when they were filing the memorandum of issues, the AG as part of the memorandum of issues set that down for determination. Now, the question was whether or not the case was properly before the Supreme Court and if the Supreme Court had that jurisdiction to hear the matter.
That's right.
That had come up already. And then the Attorney General was impressing on the 7-member panel to say that yes, indeed, there was jurisdiction because the 5 had already determined that matter in the applications. So you recall that when the Speaker of Parliament made his application to vacate the ruling of the Supreme Court itself, the matter of jurisdiction came up and they decided.
That's right.
So the Attorney General was simply saying, when the matter of jurisdiction came up again on the substantive matter, that this matter has already been settled on. Let's go on so that it will be taken that you have jurisdiction to hear out. Of course, not all of them agreed. Tango in particular did not find favor in that particular argument because he thought that jurisdiction as it related to the application was different from as it related to the substantive matter. And he sought to distinguish why they still needed to consider the matter of jurisdiction. But of course, they looked at the issue of jurisdiction. These 5 agreed that indeed they had jurisdiction to hear the matter. These 2 disagreed or they dissented.
Right.
Now, into the other, the substance of the matter itself. I mean, the case as to what exactly Article 97, 1, G and H actually means. That's why it gets interesting. It gets interesting because the justices took their time to break the article down or the provision down just so they could interpret it in a manner that we all can follow.
Right.
But at the end of the day, what essentially stood out and which they took their time to actually tease out was that when you want to appreciate this particular provision, it has to be seen in a certain sense. That one, an MP, for an MP to be deemed to have vacated his or her seat, that MP must have left his party. To leave your party, and that's the party on whose ticket you came into the house.
So, for instance, so Cynthia Morrison
came on the ticket of the NPP. So she must have left the NPP.
As in resigned from the party.
Yes.
Okay. But
so they did not go into that, but per the provision, there is leaving the party and joining another party. So the contention is that, or the argument made is that you must have left the party and then join another party, and then seeking to remain in parliament on the ticket of the new party that you have joined. So let's say, for instance, you as an NPP member, you left NPP, you came to parliament on the ticket of NPP, you left the NPP, and then you join, say, NDC, and you seek to remain in parliament on the ticket of the NDC. In that case, you would have been deemed to vacate your seat.
Not that you have the intention of contesting in 2024 as an independent candidate.
So they actually make the point that leaving the party and joining another party has to be seen to be contemporaneous. It means that it has to be now. And the definition of parliament, as the justices have explained, is within the period of 4 years. So this particular parliament has a lifespan,
right,
which was from 7 January 2021. It will end on the 6th of January 2025. So within that period of time, if you change your identity in the house and you seek to still be in the house on the new identity, that will not allow you. So that's how come they summarize it in this. And this is in respect of the age, which applies to members who came on the ticket of parliament, on the ticket of political parties. That one, so yes, it begins here, that an MP must vacate his seat if he leaves the party under which he was elected to join another party or become independent, and seeks to remain in parliament under new identity. So for them, these are the elements that need to be met for one to be deemed to have vacated a seat if you came to parliament on the ticket of a political party. In respect of the age, which applies to independent candidates, these are the elements that were formulated by the Supreme Court in aiding us to understand what the provision means. That one, an independent candidate must vacate his seat if he joins a political party in parliament and seeks to remain in parliament under his new political status. It does not apply to an intention to contest a future election. After explaining this, they took their time again to explain what the implications of what the speaker did would mean.
Tell us about it.
They make the argument that it will affect the rights of MPs to have a choice, that MPs, even though they may have come to parliament on a ticket of a certain party, they still have that right to make a choice as to which party they want to ride on in the next election. So if they make that decision for a next parliament, that should not be seen to be a vacation of their seats. They also make an interesting point about how parliamentarians have a social contract with their constituents and not with political parties.
I see, but they came into parliament on a ticket of a political party.
But they were elected by constituents and they are accountable to the constituents.
I see. So does that mean that the political party then doesn't have a say in whatever the person says?
But they still make a point that it should not be left in the hands of the political party to decide the parliamentary imbalances with internal party decisions.
Does this then negate the provision in the NPP constitution specifically about the forfeiture of the membership? Because if you look at the constitution of the NPP, they state, and we're going to put that constitution of the NPP on the screen in a bit right now, that you automatically forfeit your membership if you, as a sitting MP, decide to either contest on the ticket of another political party or go independent. The automaticity of that constitutional provision kicks in immediately you decide to.
Unfortunately, that did not come out expressly, but when you read in between the lines of what they said about not leaving this decision in the hands of internal party decisions to be made as to altering the composition of parliament, you begin to appreciate that the Supreme Court wants to take that power of the political parties being able to influence the shape of parliament. So they make that case of the connection between the member of parliament and the constituents rather than that connection between the member of parliament and the party that brought that particular candidate into parliament.
Busiafo ede nyankasa tiwe assume as we speak no a reason why a Supreme Court no gina so this interpretation e by no inu no matombo ase acheche mu ye na a raise a lot of alarm just enya asempeto chichemu abe amanfo ase omodwen ho monti ase o omodwen ho monti ase bi mo ka se we partisan interpretations and bi mo kan ake intino as you speak no niema APA free this interpretation mo ba no like ebi mo ka say Ghana ye free fani ababedru sabri how come say ade ya atwira to ho o read JHS ni a oti ase we nye de say o kodwen ho debi mean kan SHS ni JHS ni o te brofo o de badwia oti ase ade we da obam ebi abrofu bi ye huhu ambiguous bi dia okay here nim the form of machejemu na we are chechemu simple na interpretation e ba dia na chese e man for say ade ha dwin ye pa na the one say every party be on the constitution including NPP for chese amodi Kesi we especially Afenyo NPP MPA leader or mono or say na majority ni ankanto ya kasa ni afa majority na antato a onu benya asem na so as we speak no parliament enya declare more stands in Tibeka say NPP MPs formal leader omo nipa ne di sa Kesi ne ko no party omo free mo buy on the ticket de ne call parliament no sa party ni constitution say nipa bia obe declare ne support see o declare ne support keke support so support will be from different party. Say any pano ye ni film an example esi hopes and doye one ye chese enkrofo bebre ye bi ohini nto omunyi na eden ye yoma film o man ka say omo stand as independent o omu declare omo support keke party ni gina constitution na omunya free Ghana constitution me eden omo free party ni na we die nyezi ni pani declare ne support o the panel jai party no akwa as independent candidate o jai o declare support kre you from na o jai wan kasa mu jai ene ambassador bi intimi ne sa inti ade a lot of tensions are then ababeto omo party ni matches enyas because constitution no the got the omo party constitution from Ghana's constitution ti ba ni say na just say ade hardin remember Nkrofo me NPP NPC a omukazo muko for independence. Ba ko babontin kodwa asante no obabontin ebeka se omo parliamentarians no mo NPP side no. Omo WhatsApp group omo mo discuss bibia agenda ombe bia wom no. Eye anodon prayer se when majority chief whip. Then majority chief whip. Sa ono no. Eyi sa nkrofo mkazo muko independent ni nyina efrim. Tio we omo efrim. That means already no omo ankasa atiase se omo nka omo ho. Na dia wo yi na efrim no ene wa ko fight to Supreme Court chinchin etwa waka ho. Jare na wo yi na efrim even on your WhatsApp platform. A mere WhatsApp platform keke. Ne kana se who as a political party or no declares on come who be ma. Moso eni anka. Ti se ni de niema epie from bano. Omo ankasa edi so bono airtie eye Afenyo market so a chisen asan kiti nchechim bibiri betima chi adwa na the comment section. Subscribe na share ma onya so den san ke be 100% musi.